right. The defendant, Mr. Eiserman, has come on into the courtroom. Again, it's Joseph Carl Eiserman III. He is currently in pretrial custody. Day 4, a sentencing, and Miss Simmons is now joining us, Mr. Stapleton. So you can step away from the table and recognize Miss Lindsay Simmons, the agent from the Michigan Department of Corrections. So, Day 4A sentencing. I'm going to take a quick look to see if I noted any need for corrections. Right. All right, I don't think I caught. Oh, wait. The case over in Ludington, Ms. Simmons, the one that's entry 13 of 13 of CFJ 284, page 11, it says pending. Looks like the alleged offense date was January 9th. Have there been any update to the status of that case?
Not that I'm aware of, Your Honor. No, it's still pending.
All right, good enough. Checking. And thank you. Mr. Carnes, do you have any amendments, corrections, or objections to the contents of the PSI?
No, Your Honor.
How about you, Mr.
No, Your Honor. I discussed this with my client. Changes requested.
All right, thank you very much. Do we have any victim impact statement today?
Yes, Your Honor, we do.
All right, thank you. Ma'am, please tell me your first name
Jessica
and your last name,
Gardner,
and would you please spell the last name?
Gardner.
All right, thank you. Yes, Ms. Gardner, what is it you'd like to say today?
April 2nd, 2016 is a day I'll never forget. That is the day my life changed for the better and for worse. I say for the worse because that is the day I became a victim to domestic violence. I experienced hours of abuse, of being hit, slapped, choked, taken hostage in my own home and vehicle. A place that was once my safe place, my home, was no longer safe to me or my children. I never experienced this fear in my life before, the fear of wondering if this was going to be my last day alive, if it was going to be the last time I've ever seen my kids again or my family and friends. I was frozen, unable to defend myself against someone much stronger than me physically. I remember wishing for someone, anyone, to come save me, to knock on my door or even stop by and say hi, but nobody came. I had to save myself. After everything that had happened, I was afraid to be alone. I ended up living with my mom and her husband for roughly about 2 months. I didn't see my kids for about 2 weeks, roughly, so they didn't see the bruises on me. When I was finally ready to go back to my house, my mom and dad cleaned it up for me, so I didn't have to see any of the damages that was done. They replaced all my locks on my doors with new keys, so nobody had them but me. They patched everything they could to make it feel like a home again to me, but it wasn't. I was still scared to be alone. I ended up moving my brother in with me so I wouldn't be alone. I never went anywhere alone. The things that I enjoyed doing outside, I could no longer do out of fear. This put extra stress on my mom and dad because they had to do all my errands for me. I, as a victim of domestic violence, was put into counseling and therapy at Oasis for 3 months. I then switched my counselor to Life Skills and was in counseling for about 4 years. Therapy helped me overcome my fears of being alone, relive my trauma, love myself, and learn to see the red flags in people. I say for better because I no longer classify myself as a victim of domestic violence, but as a survivor. Although I will never be the same person I was before, and I still suffer from PTSD, I am now stronger than I once was. I am a successful mother of 3 children, a store manager. I own my own home, my new safe place. Since my case has been moving forward, I have found myself being more anxious and startled. I do have trauma that'll never go away, even with therapy. I just know how to handle my situations better. I do, however, have a fear that Joe will want revenge when this is all over with. And for that, I am asking for protection for my kids and myself. I do not want what happened to me to happen to another person. And for this, I'm asking the court to give prison time, not only for the safety of me and my kids, but for the safety of the public in general.
Thank you. I'll start with the people. Mr. Carnes, go ahead, sir. Allocution on behalf of the people. Sir. Thank you.
Yes, Your Honor, thank you. It is, I'll just say, very unfortunate that it took this long to bring this case. To get Mr. Eiserman arraigned. Obviously, we were 9 years behind the ball. I apologize to Ms. Gardner for that. Couldn't discuss that with him before. For it. Your Honor, there's this behavior which is absolutely abhorrent as it's described in the PSI. And defense counsel has made arguments to me that the defendant has changed, but then we have this pending bond violation, which I think illustrates that he has not changed. Given that, I think 23 months prison is appropriate. It's what Ms. Gardner is asking for, a prison sentence. It's within the guidelines. I'd ask the court to approve that. Thank you.
Mr. Diego, sir.
Judge, a few things on behalf of my client. I think that the court can take probably unfortunate note of similar difficult cases where there's significant danger or attempted danger that a defendant may put a complaining witness in a case like this while on bond. That has not happened in this case. Mr. Eiserman, while he did move away from the area, reside in Illinois and had some unfortunate and somewhat minor contact with the criminal justice system there, has been back in the area for approximately 5 years now. He's not contacted Ms. Gardner, has not threatened her or her children at all. And as the PSI writer indicated, his focus has been on parenting his 2 minor children. He was gainfully employed. And yes, of course, there's significant allegations pending in Mason County. I'm aware of those. I'm intimately aware of those as our firm is representing Mr. Eiserman and those as well. He's adamant of his innocence on those, but they did occur while on bond, so he doesn't shy away that they're there, and he just wanted me to emphasize to the court that he plans on fighting those till the end. I think that, Judge, in this case, certainly the description of the offense narrative taken from the police report and hearing Ms. Gardner's statements today are quite powerful, and I'm sure that they made an impression on the court. They frankly made an impression on me. My client did take responsibility. His version of the offense may be unsatisfactory. I'm sure it's unsatisfactory to Mr. Carnes as well as Ms. Gardner. But nonetheless, as Ms. Gardner just address the court judge by him pleading guilty in this case, ensured a fast track resolution, avoided additional potential trauma for her. And again, the fact that he has been otherwise bond compliant, has had no contact with Ms. Gardner or her children, hopefully does bring some additional insulation for Mr. Eiserman. Ultimately, he sits before you, Judge. His focus has been what has been consistent in my communications with him. He's worried sick for his children. I wasn't sure if I wanted to bring this up, Judge, because I don't have any supporting documentation, so I'm somewhat speaking as a layperson outside of my element here. I do fear that there's some mental health difficulties that Mr. Eiserman has, that he has not self-actualized, have not been diagnosed. I know that from, again, having privy to some other materials, he has family members that are concerned about him potentially being an undiagnosed schizophrenic. His behavior and his ability to maintain focus and or his emotions, frankly, comes and goes even in his interactions with me. And he's someone that, and I was privy to another defense attorney making somewhat a similar point on behalf of one of his clients earlier this morning in the courts. My relationship with Joseph has always been positive. So when I noticed that type of change in a behavior of one of my clients, again, from a lay perspective, it causes me some concern, and hopefully throughout whatever period of incarceration the court determines appropriately, perhaps he'll be able to get some assistance on this. I certainly will encourage that he does so. That concludes my comments, Your Honor. We're not asking for any specific sentence. We're asking that you look at the totality of this, the report, the circumstances being as difficult as they are, and also Mr. Eiserman's conduct most of the time on bond, and fashion a sentence you deem appropriate. Thank you, Judge.
Mr. Eiserman, you have you have the right to make a statement before I issue a sentence if you choose to do so. I don't hold it against people if they don't, but it is your right to do so. Is there anything you wish to say at this time, sir? You may remain seated because I know you've got shackles or cuffs on. Whatever's the most comfortable for you.
See that?
Take your time.
My boss told me don't go with her. He knew her and her mother. He warned me that she'd been through multiple relationships, as well as her mother Denise, multiple divorces. He told me not to go there, and I did. And I made it, and we did. I did make some mistakes. I loved her with all my heart, and I moved my children, and I paid the rent. She quit her job. I took care of everything there, and her brother was already living there. She didn't have to move him in. He was living there because I said, yeah, you know, you know what, I apologize if she's hurt, and I shouldn't have caused her that type of pain, and I'm sorry for it. I'm sorry that I caused you problems, Jessica.
All right.
Just briefly, we will agree to the restitution as outlined in the PSI.
Thank you. All right, so there's quite a few things here to unpack. It's apologies. In a criminal case, apologies are often wanted from victims, and they're not always given. So I appreciate and acknowledge that Mr. Eiserman gave one. I know, though, once an apology is made, it doesn't often make everything feel better. I know. Plus, obviously, there's the way the apology is made, too, that the court takes into consideration. There's one thing I made note here on it, and I don't blame Mr. Yagos for presenting the argument. The right one to present, and that is, hey, you know, court, please think about the fact that he provided closure by entering a plea and avoiding a trial. And sometimes that's a very logical and reasonable argument to make. And as a judge, I never know what to say. Because you're either damned if you do or damned if you don't with an appellate attorney or an appellate court. Either I say, yes, congratulations, let me knock off some time because you pled guilty, but then it looks like I'm punishing people who don't plead guilty. It's one of those things appellate judges never actually take, or courts take into consideration, or the appellate attorneys, because I don't know how, I don't even know what to respond, but I will say it's a good thing that he resolved it in the way that he did. Then you get closure to some degree. All right. When I look at what the defendant's comments were a few moments ago, I was taken aback by them. And in here, when I looked at his statement as to what happened, it says, quote, I pushed her away from me, end quote. Why did you do it? Quote, we were arguing about my ex-wife and I pushed her away from me, end quote. First of all, I don't know which ex-wife, because it sounds like, according to the PSI, he's still married to some woman someplace, and he got married to when he was 16. So I don't know if it was an ex-wife or the real wife, whatever. But the I pushed her away from me is not what happened. And the details in agent's description of the offense are the ones that I take notice of. Quote, nobody does this to me and walks away without finishing it, end quote. Pushed her, grabbed her by her throat, pushed her up against the wall, grabbed her by her head, slammed his forehead into hers, choked her multiple times, punched her in the mouth, side of her head. And that's only about 4 lines of 2-page agent's description of the offense. So I'm not going to read all of those again, Jessica, because I don't want to make you relive them any further than you already have. But the comments today made by the defendant, as well as his explanation, are not at all what happened. Turn around and to blame the defendant and say, well, I was told I should never have gone there. That don't cut it. So.
Have you read in the report where she
Stop.
omitted?
It's all right, it just is a, hold on, I'm not gonna react overly negatively.
Yes, sir.
That's okay. So, Mr. Eiserman, I allow everybody to have their time to talk. And I let them talk freely. I even tell them, like I told you, take your time. But now it's time where the judge gets to make a statement. It's my turn. And so, thank you. Now, this did take some time to get to because the defendant had left the area. All right, let's take a look at the defendant's criminal history. He has 13 entries. We know that not all result in convictions. I acknowledge that. For instance, I know entry 1 of 13 was dismissed. Entry 2 of 13 was dismissed. So clearly, I don't take anything away from those. I will note that on 3 of 13, this one in 2004 occurred while on bond. Again, it was on bond for a case for which he was, the charges were dismissed. But this one, we had an aggravated battery in Illinois. So already, starting from the very beginning, you're seeing crimes of violence. The defendant received a 3-year prison term in the Department of Corrections for Illinois. Then in 2007, after he had been discharged for about a year, he then picks up a domestic battery causing bodily harm, also in Illinois. Actually, in DuPage County. I used to live in DuPage County. He got 2 years of probation. That probation began on November 19th of 2007. And he got his first probation violation less than a month on December 7th for a new domestic violence case. He was ended up being terminated from probation unsuccessfully. Well, as I mentioned, he picked up another domestic violence. Oh, I'm sorry, I misread that. So he actually violated probation, like I said, within a month on December 7th, and then again for a new domestic violence, which is entry 5 of 13, where the offense occurred on January 13th of 2009, and that was another domestic battery causing bodily harm. And so far, that means he's racked up at least 3 different violence. Well, he got 2 years of probation. That sentence began on March 23rd of 2009, and he made it less than 4 months because he violated probation on July 17th of 2009 by threatening a public official and driving while under the influence. So it's right back to a continued pattern of violence. One moment. Then, about a year later, so by the way, on that last one, he was sentenced on July 21st of 2010. Oh, then he picked up a charge, but I'm sorry, that was dismissed. I apologize. In 2014, he picked up a drunk and disorderly. Now he's back up here. That's Wexford County. That was December 17th, 2014. He made it less than 2 years before he picked up another charge, and he picks up a domestic violence, which is the case that we're here for today. Meanwhile, that charge, he doesn't get arrested for about 9 years. Then he gets brought back here. In the meantime, while he had been gone, apparently back to Illinois, he picked up an obstructing identification. I assume that means lying about his identity. 2 years later after that, he picked up a obstruct a police officer. Then he made it a couple years, and then he picked up another disorderly person charge. Note here that one of these offenses was failing to obey a traffic signal. Not a big charge, but according to the rest of the history, he hadn't had a driver's license in nearly 13, 14 years. He's able to drive and do what he wants. And then I can take judicial notice and make a finding of the based upon preponderance of the evidence, the factors that have resulted in his new charges over in Ludington. The reason I can do that is because contained here in the court file is the program violation through community corrections that was submitted to the court by that office on January 26th. And attached to that report was Ludington Police Department incident report number 26-2600. And that describes the allegations for the sexual assault charges pending against him in that county. Now, again, I don't make a finding of guilt, but I can take it into consideration in establishing a reasonable and proportionate sentence. Now, I'm not going to use it to exceed the guidelines, so therefore I use it for a very limited purpose, because I don't want to create another appellate issue, even though sentencing is within the discretion of the court and the guidelines are not mandatory. I am going to take it into consideration to some minimal degree. The amount of restitution being requested here, Mr.
Your Honor, I quickly did the math. And just for Mr. Diego's benefit, I did use the maximum for the hole in the wall, but the minimum for the phone, and arriving at $754.53.
All right. So again, plus, that's another act of violence here. That seems to be a pattern for the defendant. Court sentences the defendant as follows: a $68 state minimum fee, $130 crime victims rate fund fee. The processing of this case has taken multiple months, including representation at a preliminary exam and multiple appearances here in court. So therefore, the court assesses a $300 court cost, a $300 attorney fee. The court assesses $754.57.
53 cents.
53 cents for restitution payable to Jessica Gardner. Do we have, or do we already have DNA here? I assume we
It
did.
says no DNA.
No?
fee on it.
All right, so we have no DNA fee. The court is not going to assess any fines. The court sentences the defendant as follows. Again, keep it within the guidelines. This is a domestic violence third conviction. It could be, I guess, a domestic violence third plus also, other prior acts of violence. And it also has a long history of alcohol and substance use. Its crimes crossed multiple states. The court sentences the defendant to a prison term of 23 to 60 months, and the defendant provides the defendant 15 days of credit. I find that that is a reasonable proportionate sentence. I find that underneath the language of MCL 771.1 parenthetical 1, that the court is only to give probation where it feels there's not going to be reoffending. Again, the defendant has a very violent past. Therefore, I do not find that probation is sufficient and that this is a fair, reasonable proportionate sentence. Have I missed anything, Miss?
No, Your Honor, thank you.
Mr. Mr. Carnes?
No, you're right.
All right. Mr. Eiserman, Mr. Diego's is bringing you 2 copies of 1 document. You're going to place your initials on the first copy. When you do so, that copy will then be brought back to the court. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of the document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document.
I have a right to appeal,
I'm sorry?
so I can appeal this.
Yes, sir. It's by filing what's called an application for leave to appeal versus a claim of appeal by right.
Well, because she left out a bunch of shit on her stuff. She's like, well, the reason I lied about hitting him is because I didn't want to get in trouble. And the reason I lied about being at his ex-wife's house is because I didn't want. Of course you want to lie so that you don't get in trouble. We all want to lie so we don't get in trouble. We need to take that stuff into account.
Yeah.
She was a man-eater.
Maybe the defendant did the same thing. And I'm going to tell you, and I appreciate your compliments or comments because they get made a part of the record. And that reaffirms the court that the decision of the court in its sentence today is fair,
Okay.
reasonable, proportionate. Good luck.